people like Scalia will say no, that's what it meant at the time, and just because now you could conceive of different rationales doesn't mean that you should necessarily get rid of it. That I would say that's more of like a values thing on your judicial and interpretive philosophy.
Yeah, it's that originalist bullshit. Like Scalia, I don't give a fuck how much people respect Scalia as like a law person. Some of the shit he used to, like the thought experiments he used, are just fucking ridiculous. Like, you can't tell me Scalia was like some sort of objective genius or some shit when he used the dumbass argument back during like Iraq War, George W. Bush times of if there's like a 1 in a trillion chance that we can stop a nuke from going off, then we have to run the risk of just torturing folks, you know? Like that 24 fucking Jack Bauer type shit. Like that kind of argumentation is so thoroughly refuted in so many fucking fields, philosophy and fucking just everything, and ethics and political philosophy within that field. Like, no one buys that. But then here comes this originalist motherfucker with this outrageous argument that just sort of like plays on people's like fears and insecurities about a major nuclear strike. It triggers the fuck out of me. Like, I feel like Scalia should have never been near the government if that's his thinking.
I suppose.
Okay.
But it's a
I
good.
don't even like hearing that motherfucker's name. I think, yeah, he's like Newt Gingrich. He's part of the foundation for the fucking nightmare we have now.
Point to bring up. Back to strict scrutiny.
Okay.
That has typically, this is the most searching inquiry. Now, when you're in the strict scrutiny world, that's when you are entangling in a fundamental right. That's when you're making a classification based that's suspect. In the context of equal protection, that's going to be racial based classifications, national origin based classifications, whether or not you're a citizen for state governments. Keep in mind, the federal government's able to classify and discriminate non-citizens, but state governments are presumed that that's a suspect classification because the federal government has the power to do immigration and all that stuff.
Okay.
Those kinds of classifications are ethnic classifications, and also fundamental rights, as I mentioned before. So classifications, or sorry, laws that might infringe. Let's see, a law that is content non-neutral or viewpoint non-neutral in the domain of First Amendment law, free speech stuff. That's going to be a very high level, heightened scrutiny, maybe even strict scrutiny. Those kinds of fundamental rights get treated a lot harsher. It doesn't mean you can't overcome that kind of stuff.
Sure.
You can overcome if you have a good enough reason. If it's a
Yeah, exactly. Only a white fucking like cis Christian person who probably at least middle class background, all that shit. That's the kind of person who thinks like Scalia, who's like an originalist dumbass, and that's the kind of person who found that sort of argumentation he used to give in favor of stuff like torture convincing. That's it. Those are the people. That's Scalia's people.
compelling reason. These are national security.
Yeah, you can overcome literally anything. Because I think somebody, like, the First Amendment is...
Just, burn and pillage. Yeah, exactly.
thought of as, like, the most important one, but, like, freedom of speech isn't even absolute. Like, all of these rights are contingent on other things. Yeah.
For different reasons, right? One reason for the First Amendment stuff is, well, this is not even speech. That could be a reason. So think, if I say driving my car into someone, that's...
Yeah, Scully is like proto-MAGA type figure. I mean, he probably... I think he would be one of the people who wouldn't be real on board with Trump, but would be a little Trump skeptical if he were alive and everything. But he's like one of the figures preempting MAGA, basically. You can't get to like the situation we have now without people like Newt Gingrich and Scalia, no matter what their attitude on what happening might be. And yeah, it's like these people don't understand that a bunch of the country interpret like fucking MAGA or originalism as a kind of threat, it doesn't like cross their mind because they're just part of this completely different class of people with totally different experiences.
speech. You could be like, well, no, that's not speech. So you could have an argument about whether something is speech. But even assuming that something is speech, the government might have an extremely good reason to make it an unprotected category of speech,
Sure.
or might have a really good reason for why viewpoint discrimination in this case is really important. But yeah, so the tiers of scrutiny, I think, is a worthwhile analysis, and it gets you in the sort of frame of thinking that and he's right, or they are right, I don't know what their gender is, when they say that the fundamental rights aspect does not perfectly line up to the equal protection context and the tiers of scrutiny stuff. I believe it is the case that the equal protection kind of approach came first, and then the fundamental rights stuff kind of got mapped onto it. And a lot of the fundamental rights stuff there's problems related to mapping that on perfectly. First Amendment doctrine, for instance, does not map perfectly onto strict scrutiny analysis. You'll have different for time, place, and manner restrictions with speech. It'll be a different rule. For speech in schools, it's a different rule than strict scrutiny, and a bunch of different rules with respect to incitement. They're kind of sui generis, or is that the term? I don't know, the term meaning unique.
Okay.
And so that's true, but it's kind of the way we look at fundamental rights is first identify the right, and then identify the state's interest. And so that's why I was trying to get us in the mode of analyzing whether or not you even agree that there's a fundamental right to abortion. What Alito is doing, in his opinion, is he's not doing what you were doing. In the argument, you were focused on, well, the state's interest here is obviously different between a fertilized egg versus sperm. And I'm not going to deny you that there's not like some factual difference that is maybe even significant there. I'm not going to deny that to you. You know, a sperm is different than a fertilized egg. But you were kind of looking at it from, well, of course the state has a bigger interest in something that's closer in time to being born. But that's not what Alito's doing. Alito is denying that there is even a fundamental right to abortion at the rights analysis before you get into the state interest analysis. And he's using...
But then what does that mean? Because I still... So they're trying to hash out this thing that I found really irritating, where he kept saying, well, you're talking about state interest. We haven't even dealt with the right yet. And I understand he was doing that because it's probably some sort of legal structure. But he didn't flesh out why that's the case. Because I still don't get it, where it's like, okay, whoever, Scalia or Alito, whoever they're talking about, says there shouldn't even be the right to abortion. So what does that mean? So does that mean we don't even have to discuss state interest and they get to act arbitrarily? So what happens as an alternative to, like, you having a right by default? I think he hasn't explained that, and I find it confusing because in my ideological framework, I just think, well, I don't give a fuck if I have a right. The government doesn't just get to do something. You know what I mean? So that sort of like chafes me wrong. And I feel like that might be happening again unless he explains it.
Phrases in Roe and Casey and acknowledgments by the court.
Like, for me, without having some sort of structure that informs me why we have to look at the rights before state interest, you know, for me, I don't give a shit. You know, I don't operate on just like, you only can't do things to me that I have a fundamental right to. I only understand that in terms of like making the world work. My personal view has nothing to do with that, you know? And so it's like foreign to me.
In those areas about quote unquote potential life, which is in the context of Roe and Casey, discussing the state's interest, as one naturally would. When you're thinking about potential life and that kind of stuff, you're thinking about state's interest. And he's not doing a thorough analysis of distinguishing abortion from these other, from contraception and all that stuff.
Sure.
And so my goal, Destiny, was to make you look stupid. My goal was to make you look stupid by either getting you to deny that there are implied rights, which you smartly did not. You did not deny that there were implied rights. At the beginning of our conversation, we agreed that there were implied rights. But if you don't agree that there are implied rights, I'm going to start giving you a hype.
Yeah, there's like a million different things, like interracial marriage contraception, the easy ones that people bring up, of course, fall immediately. Yeah.
So if someone denies that there are implied rights, I just throw a bunch of hypotheticals at you that make you look insane.
Sure.
And
but
then
if they're like a
eventually
hardcore conservative originalist,
they'll
they'll
bite the
probably
bullet.
they'll bite the bullet on all of it. Say, yeah, I think that it should be up to the state to decide if sodomy is legal or not, right? Yeah.
they'll bite the bullet and they'll say, the more ridiculous the hypo you give me, the less likely it is to occur.
Sure. Or
Right?
that. Okay. Sure.
But you know, then I'll say like, are you crazy? Have you looked at these laws? And if they're really like a conservative, you give them the vaccine example and you say, does the state have the right to mandate vaccine?
Yeah, that is kind of how conservatives have been doing it, where they do this thing where first of all, a bunch of fucking conservatives understand nothing. So this makes the situation a lot more complicated. But what they really don't understand is the fucking law. And they don't understand how their rights work. They only understand this, like, cartoon baby version of basically, like, the Constitution and Bill of Rights. And so they understand so little about the law, they don't understand that the state doesn't have the explicit right to force you to take a vaccine. That's just not how, you know, the law. There's no state says that because they have higher order rights to like conduct themselves that don't use that exact verbiage. So because the conservatives can't find that, basically, with their tiny little baby brains that don't understand anything to begin with, they think that thus the state can't do that. And basically, in my mind, the sole reason why we'd enforce people much more concretely with a mandate is it would have caused the political situation to boil over in this country. Because although I'm an anarchist, I also believe it would be within the rights of an anarchist society to mandate everyone get a certain kind of vaccine if the alternative is dangerous or you get kicked out. You know what I mean? So even within like my ideal society, I can imagine a way in which you get repercussions for not helping protect everybody. So, you know, it's like it goes to show the kind of fashy shit the conservatives are thinking with now, where they just make shit up, like out of intuition and by just like bringing together all this weird shit. What seems to actually be conspiracy theories a lot of the time.
And the punishment for not getting the vaccine is a death penalty.
Sure.
And you get them
and
back,
they would
right?
have to say, they would have to agree, well, in the Constitution, your right to not be vaccinated isn't specifically enumerated, so fine,
Correct.
states can make rulings based on that, sure.
Yeah. So like, and you can get people to bite, but usually what you get is someone's like, okay, there are some implied rights.
Right.
And
Yeah, but
so
as soon as they've opened a can of worms on that, then you need a qualifying basis for it, and then
now
from
you
there,
need to
Yeah, and then you get them into this big ass slog. First of all, they're just a conservative, so there's like a 95% chance they don't know anything. Maybe you'll get that odd conservative who does a little bit of reading, and so they're like, they can work through stuff, but you can just slog someone down like that by basically getting them into a discussion where they have to construct so much system to fix their like stupid idea that could eat the entire rest of the discussion.
distinguish
Like very easily, especially with a conservative.
why is abortion not one of them. Now you can move the burden to me, and that's what I think you should you try to do multiple times. And I was a little bit shifty, right? You were like, wait, why you should be the one telling me why abortion is a fundamental right. Why am I in the position of having to distinguish contraception? Shouldn't you have the task?
Sure, because if it's not enumerated, you need to tell me where the right is coming from. Like, how is it? What does it imply?
So I didn't really explain
from?
that well,
Sure.
but I'll do so now. The idea is pre-Roe, there were a bunch of cases that were establishing the kinds of fundamental rights that the court was willing to hear on and was willing to grant. And it wasn't doing it in the kind of for the reason that we're doing it in Roe. A lot of these earlier cases are either like equal protection cases. The case I cited to you, Skinner, that's the sterilization case. By the way, that sterilization case did not overrule a previous case, I think it's called Buck versus Bell, which it seemed to be like sterilization is okay, guys, but we've come to understand that nowadays sterilization probably wouldn't be upheld by the court. But you know, the cases that were before Roe were kind of like equal protection cases, or they're citing other aspects of the Constitution, like the Ninth Amendment or the penumbras of the First, Second,
Sure.
or sorry, First, Third, Fourth Amendments, that kind of stuff. And the reason why I think abortion falls in line is because the key cases like Griswold and Eisenstadt, and that's another contraception case, and Skinner, they all kind of had to do with these like intimate decisions about whether to bear or beget a child. That's kind of like the core of what's at issue in those cases, is that now you could say Griswold is more about the privacy of the home, the marital home. You could construe those cases that way, but it doesn't quite fall in line with Eisenstadt, which isn't really about the marital home because they're not married, you know.
Well, my understanding is that the non-marital home, the marital home was the big argument, and then the non-marital home was basically just an invoking of the 14th Amendment's equal protections. That's the only way that they made that jump. That's my understanding of it.
People had different opinions at the time. Yeah, yes,
Okay,
a
gotcha.
lot of these were equal protection cases, but the court was making. It didn't seem that equal protection analysis should get you there, right? Because typically when you're doing equal protection analysis, like, why wouldn't it? I mean, is married a suspect class? Is unmarried a suspect class? Like,
Well, I think
they're not.
so. I thought originally it was. I'd have to go back and read, but basically, like the marital one had to do with the idea that like having sex in your home and using contraception, like the idea that the government would ever intervene in any way there between a married couple was ridiculous. And then when a later court case came up, to provide like why are married couples the only ones protected here and not unmarried couples? That equal protections was the only.
Yeah, it's really interesting how concrete the heteronormy shit really was in the U.S. not that long ago. I think sometimes we overestimate it slightly because a lot of this shit got grandfathered in when it really was at like 100% heteronormy. But like the way they used to discuss shit back in like the 30s or even just back in like the 60s was ridiculous. And then it got softer and softer and softer until like about the 90s or early 2000s, and then people really stopped, besides the religious, really stopped thinking of everything like that. At least everything. They like opened the door, you had like shows like Will and Grace, shit like that. But when you go back 100 fucking years, they act like it's the only people on Earth, just hetero people. There's no other kinds of people. Everyone exists to eventually get married. Like, it's just crazy shit like that.
The only reason why it was extended to basically everybody was my understanding.
Right, but the logic of like the privacy of one's home, that's where I got you with the bestiality one, right? If you bite that bullet, that the government has no right to intrude you there, or if that's your rationale, and this is the problem with that being the rationale, is why the intrusion into the government, to the, you know, the home of someone, would that be any greater or lesser if it's bestiality? And
well,
the reason
is it like federally illegal to have bestiality? Is that a federally illegal thing? Has a court ruled on that?
Well, be careful here as well,
Yeah.
because you just asked if it's federally legal, and I want to get this crystal clear. And there was kind of this discussion where you were doubting me on the police power stuff, which makes sense because this is not like, because you're not a lawyer, you're a really smart guy, but it's
no, a lot of this stuff is like you just have to learn the process.
You have to know it.
No matter
Yeah,
how
it's-
smart you are, you're not gonna have any fucking idea what like
Correct.
substantive due process is. You don't
Yeah, I
fucking
don't know
read
what
through
that
shit.
shit
Yeah.
is.
correct.
Yeah, I
So
understand that. Yeah.
there's two questions when you're analyzing like an is it constitutional thing. Kind of two questions you could look at. One is this a powers question? Does the government entity in question have the power to do that? That's typically in the context of federal law or federal enactments. In the Obamacare litigation, the question wasn't, does the Affordable Care Act violate some individual right? The question was, does Congress even have the power under the Commerce Clause or the Taxing Authority to enact this legislation? Congress is a government of limited powers, and so typically we don't think of them as having the quote unquote general police power that states do.
Yeah.
Now states are limited by their own state constitution.
Right. I actually think of the law in the United States, federal law, as being granted by the states. You know what I mean? So I don't even know if that's technically correct or if that's like a consensus view. But I actually personally I don't view the United States as like just like the federal government and then we have all of these provinces or something. I actually really do view the United States as a bunch of different states granting the federal government a bunch of capacities. And then so anything illegal in some state, the federal government is, unless there's some other contravening reason is obliged to enforce the law of that state within its boundaries, etc. So I see it as sort of like beginning from the bottom, then going up to the federal government, then back down, you know? So when I think of something being illegal federally, I think it falls into two camps. Either some state doesn't have it illegal, and so the federal government illegalizes it, and since no particular state has a qualm about it, or not enough of them, it's stayed illegal federally. Or if something else can be illegal via just being illegal in a state, because the federal government is obliged to uphold laws of its constituent members, basically. So sometimes I don't, I have like this completely different image, I think, of the federal government than a lot of people.
But the reason why all my examples are state, because I don't want to get into a federal powers question.
Yeah, like it's not obvious, but there's a lot of different philosophies on how the federal government even exists, like what it is. Some people are like they're heavy federalists, and they view, say, the executive branch as like they want that to be a unitary power, and other people view the United States horizontally, like I do. And I would actually have to say the competition between these two things defines a lot of our national domestic politics.
Where we're wondering whether or not the Congress even has the authority under the Commerce Clause and all that stuff to do the enactment.
Yeah, I view it as one country only in virtue of everyone agreeing it is. You know what I mean? I don't even see the Constitution as that important, to be honest. Not itself. Like, if all the states just decide, or enough states decide to break up, the Constitution is worthless. I don't think it really binds everyone unless there's such a powerful monopoly of force by the remaining union that it can force the rest back in. So I don't even view it as like this concrete entity. I view it as like this very pragmatic thing.
I want to avoid
that's basically the Civil War, right? Even if you just don't look at the morality of some of the things that was going on, that's basically what the Union did in the Civil War. Even though the South basically started it, blah, blah, blah.
that question.
I don't want to get into that, but that's what happened on paper.
And avoid like the, for instance, like the drug war. You could think of it in two ways. One is, where does Congress get the authority to regulate drugs? It doesn't say in the Constitution that it has the authority to regulate drugs. Another one could be like, well, drugs is an individual right. My ability to ingest drugs is my right. And so that's a powers question and a rights question.
Sure.
And so when you just now said, like, well, where does Congress have the authority to?
Yeah, the powers of the federal government are very abstract and fucking weird. And actually, the dominant view of the power of the federal government seems to be different between the average American and the average person in government. It's very strange. It really is kind of like a ruling class. Kind of. It's like a new version of that.
Really, bestiality. You could say something, if you wanted to stick it in Congress or wanted to stick it with the federal government, you could have like, it shall be illegal to commit bestiality in interstate commerce, right? And that could kind of save you. But you avoid that question entirely by just, because we know that the Bill of Rights are largely applied as to the states, to the incorporation doctrine, to the 14th Amendment. Mm-hmm. We can skip that question by just saying it's a state government. And does the state government have the authority to prohibit bestiality in your home? And the reason why I was going there with it is because under the rationale of Griswold, where it's the marital home, it kind of seems like, why should they, right? And you said like, that's why your logic led you there, right? Because, well, no, I mean, if they can't stop me from having sex with my partner in my home, why should they be able to stop me having sex with a goat in my room?
Mm-hmm.
Yeah, I mean, that's sort of like this difference between like philosophy and law thing that comes up is a lot of philosophy people hear that question and they see no problem. They're like, I guess you do just get to fuck the goat, And so only certain philosophy people actually incorporate like normative attitudes in what they think should happen, So that's like a major difference between philosophy and law is, say, an American lawyer will very, very likely have to explicitly incorporate the social attitudes of the United States and even their local area into the way they view law. And I'm not saying philosophers never do that, but it's usually implicit, and you'll when some of the most famous examples in history have actually been explicit as well. Just for the most part, they would look at questions like this different.
That's why that logic from Griswold isn't super strong, because we all think the government should be able to like do stuff in your home. Like,
Well,
we
but
all
there
think-
has to be. I don't know. Fuck. I'd have to go back.
Yeah, I mean, a lot of people, they look at freedoms totally fucking different, you know, where especially a lot of Americans, when they learn about philosophy, they tend to like stuff like radical freedom or some shit, you know what I mean? So they like Nietzsche, and they like, what's that guy all the anarchists like now? I can't remember his fucking name, but he's like the hipster philosophy guy. They like the existentialists as well. You know, Americans just fucking like talking about freedom. I think it makes a lot of sense. I do too, you know? Yeah, Zizek. Yeah, Zizek is actually... He's probably one of the more popular philosophers that I wouldn't have thought a lot of Americans would like. But they just like the way he talks, you know? And he's like this socialisty guy who's not, like, in your face about it, you know what I mean? Yeah, he's like cool. He's cool because he's like he is basically on the left, but he's not like a woke scold, so people just fucking like him. Like, everyone likes him but conservatives. But yeah, Americans just like talking about that shit. It's part of our local identity. It's just freedom, freedom, freedom. And then American law people are even fucking more about it. It's crazy.
I can read things. I don't know if it